All set, Your Honor.
Okay, and we're here in the matter of Hudson Valley Credit Union versus Thomas Kalbach. And could counsel please identify himself for the record?
Good morning, Your Honor. James Pocklington of McCalla-Raymer for the plaintiff.
And good morning. And Mr. Kalbach, am I pronouncing your name correctly?
Your Honor, yes. Its technical pronunciation is Kalbach, but Kalbach is okay too.
We're going to go with Kalbach. Whatever you are. I want to pronounce it the way you pronounce it.
Let's put it this way, sir. It's Kalbach has been the way everybody else pronounces it my entire life, so it's okay.
Doesn't make it right.
Fair enough. Kalbach, but okay.
Can you please identify yourself for the record?
Sure. Sorry. My name is Thomas Kalbach.
So what's the situation here? It looks like there's quite a bit of equity in your house, and I don't. How did things get to this point?
Basically, at the time of purchase of the home, I left my old career and started my own shop. Over that amount of time, the shop did not go well. Did not have a whole lot of business. As of, I would say, 2.5 to 3 years ago, shut the shop down completely. And over that time, basically, I was paying bills, including the mortgage expenses, by spending down savings, spending down all of that. Now, that's the general snapshot. As regards to the last month or so, after the judgment to go forward with an auction, I misunderstood what the judgment and the decision meant. Therefore, I was just going. My understanding incorrectly was that, okay, a $385,000 hypothetical value was assessed to the home. That amount would be the home would be bought for that amount by the lender, and then it would be theirs and to do with as they please. Obviously, that's incorrect. So my thought was then, okay, then out of that $385,000, all the remaining debt would be paid to the lender, and I would get the remainder. Obviously, as I said, that was incorrect. In between then and now, I was disabused of that notion, found out what the actual mechanics of the auction were going to be, and sought other avenues through outside consultation. I just was introduced to the EMAP program and started the process of application in the EMAP program, but am in the middle of that application.
So what kind of shop did you have?
I'm a data engineer, data process consultant by trade. I help small businesses in particular understand how the data inputs and outputs of their company work and move them from various departments and make those data assets accessible to various stakeholders.
Okay, and are you employed currently?
I am not. I have as well as being on all the job sites, Indeed, ZipRecruiter, the LinkedIn and whatnot. I have applications. I have active applications out to the local Home Depot. I'm about to hit send on an application to the post office. I have profiles. I have applicant profiles online with the local Aldi and the local Big Y. So I am pursuing all levels of employment. It just hasn't happened.
Okay. And I just didn't know whether EMAP requires you to be employed or not. As you know, I don't know how that program works.
The discussions that I had with them indicated that the amount of equity in the home would be a determining factor in their decision, and the amount of equity is significant.
Okay, and I bet Attorney Pocklington knows a lot more than I do about the mechanics of EMAP.
Happy to discuss it, Your Honor. So the Emergency Mortgage Assistance Program is a loan from CHAFA that income is a variable they take into account. They look at whether it is practicable for a homeowner to repay the loan that CHAFA gives over a certain period of time. Income definitely plays into that. The equity is also a factor because CHAFA wants to make sure that if there is a default on an EMAP loan, that they have the ability to be made whole in other ways. Though they very rarely pursue their own foreclosure action, they're usually more than willing to come in on a first mortgage foreclosure in supplemental judgment and do what they need to do there. But as far as Hudson's take on the motion to open, Your Honor, I at least can represent that my client is okay with a slight extension of the sale date due to the equity. So we do not oppose an extension of the existing sale. They sent me here today primarily to make sure that we didn't get restored to a pleading status and then have to incur the expense of going back to judgment, and also to keep it on a short leash in terms of the timeline. We weren't sure exactly what was going on because the motion didn't have a lot of meat on the bone in terms of what was literally going on, to have an informed conversation about the timeline. Now that I've heard what Mr. Callback has said, ultimately,
That's fine, sir.
It doesn't sound like there is a high likelihood of EMAP success, but certainly, if Hail Mary passes didn't get caught once in a while, no one would bother throwing them. So just as long as we're all on the same page that without a source of income, it is going to be obviously I'm not the one that makes the decision. I work for CHAFA on other files, not this one, but so I'm familiar with their process. But ultimately, whether it is a high likelihood of success or a low likelihood of success, it's still the possibility, and there's still plenty of equity. So an extension of the sale date would be fine with us. I would strongly encourage the homeowner to not put all his eggs in that basket and to look into talking to a realtor about private sale of the property in the same timeline. Because if there is an extension for this purpose, once CHAFA says, or not once, if CHAFA says it's not going to work, I don't want to be back here without that process, without the process of listing the property having been started. So I'd suggest a 60-day extension of the sale, and hopefully he can attack it from all angles now that he's actively participating in the action.
Thank you, Attorney Pocklington. So yeah, I'm guessing that CHAFA, and would CHAFA conceivably advance the reinstatement amount and secure that advancement with another mortgage on the property?
That's the literal definition of EMAP, Your Honor. Yes, it's a loan program to give funds to reinstate, but as part of their application process, my understanding, again, this isn't a CHAFA plaintiff file, but I do enough of them that I have a decent understanding of their process, that their process will require them to confirm that Mr. Callback has the ability to maintain the mortgage once reinstated, as well as repay the loan to CHAFA.
Yes.
Without a income, that's going to be problematic.
Right. So CHAFA says, okay, let's say the reinstatement figure is $30,000, right? I don't know what it is, but I'm just pulling that number out of the air. CHAFA says, okay, then Mr. Callback, we've got to make sure he can both pay your mortgage, Attorney Pocklington, and the new payment that he's got to pay on the CHAFA mortgage on the $30,000 that they advanced. And that's why I asked, sir, whether you were currently employed, because if you apply for EMAP and say, well, I've got a lot of equity, but I don't have a job at the moment. My instincts tell me that they're going to get nervous about enrolling you in the program.
Understood, sir. So I'll address that first, but then I want to just quickly touch on.
Let me start saying I'm wishing for you to pull this off. I don't want you to think that I'm not pulling for you.
Understood, sir. Like I said, I'll address that first, but I just quickly want to touch on something afterwards that Mr. Pocklington said. So the conversations that I had with the EMAP representative indicated to me that one of the options for their program was A, to provide the reinstatement amount, and then B, to provide a float of some period of time. The number floated was a year, but that's determined during the application process in order to make payments on the original loan. So it would be during that float period, no additional damage to the lender would be incurred. Those payments would be made. The only additional damage would be for me to the EMAP program. It would be that loan. Okay, so in essence, it would take, let's use the number you used, 30,000 to reinstate, and then call it 1,500 monthly. It would be 12 times that 1,500 plus the 30,000, and that would be the total amount of loan to the EMAP's program.
So they'll buy you a year before you have to reach into your pocket?
Yeah, and again, the year was not hard and fast. That was,
they could buy you 8 months. They could buy you, whatever.
Right.
I didn't realize
that was one of the options that the representative floated to me to be. My screen is shaking. To be floated or to be determined during the application process.
But I gotta think that part of that analysis, if you say, well, I'm going to inherit $1 million in a year, that might bear on their willingness to buy you some time. But absent some kind of concrete prospect of a realistic ability to pay, they're probably not going to sign up for get on board a sinking ship.
Sure. And again, that one of the things, again, they said that was in my favor was the equity in the home. So they might be willing to take a risk on that. And and a year's amount of time buys me the ability for all those applications, like I said, that I have working now. And the total monthly of my upkeep is not significant. Any of those low hanging fruit would be able to keep me above water, which now I forget what I wanted to do. Oh, which brings me to what I wanted to address from James in terms of not putting all my eggs in one basket. Yes, I'm being realistic about this, and if I were to get the additional time, I would definitely pursue the additional option of trying to sell the home in order to get the full value out of it.
And that I was going to jump on Attorney Pocklington's counsel. Obviously, he's not your lawyer, and I'm not your lawyer, but in situations like this, if there is, in fact, if the appraisal is sound and there is, in fact, value to be captured from the property, as painful, I don't know, how long have you been in the house?
From 2018 or 2019, I want to say. So 7 years, 8 years, something like that.
Okay. And it's obviously painful and disruptive to be displaced, but it's in most cases you can do a lot better with a private sale than whatever's going to happen at an auction, and so that's the determining reason for encouraging you, if EMAP doesn't work out, to kind of make haste to get the house on the market, get what you can out of it, and then start fresh, hopefully with, you know, a cushion of cash to for a fresh start.
Yeah, yes, sir. So as I said, even with my flawed understanding of the notification to me at the end of last month, I thought I was going to be getting a reduced chunk of change out of the assigned value of the property of 385. I was not happy about that, but I was basically in that boat of, you know what, let's take the Band-Aid off and get this done. But reopening this process was because I gained a better understanding of what was actually going on.
And the only other thing I would say, Attorney Pockington, is probably may or may not be realistic, but if there is in fact that much equity, if you were to get a job that had a steady income, maybe another lending institution would refinance the mortgage and, you know, take their chances and just start fresh. Forget about EMAP. Just go to New Milford Savings Bank or someone and say, "Here's that. There's 200,000 in equity here. I need this much to get rid of Hudson Valley. You know, are you willing to play ball with me?" And maybe I'm being unduly optimistic to think that a conventional lender would jump in, you know, given that you're in this situation now.
I just for perspective, Your Honor, and not to have Mr. Kovac feel the need to air his dirty laundry, he may have other financial challenges that would show up on a credit report that may make that less than. I'll just leave it at that.
Okay,
But,
fair enough. And I know never the extent of my familiarity with his situation, and this situation is what I've learned being together this morning.
as Your Honor knows, I like to do my due diligence and looking up names in judicials and all that. Yeah. Anyway, move. Yep. Ultimately, as I said, Your Honor, we have no problem with a slight extension. I would suggest just to, because I've got my calendar up, I don't know if an August 1st sale date would be good for Your Honor and for the court. Keep a short but not super short leash on it. That'd be a little over 60 days.
And when is the sale scheduled for this Saturday? Or
it is, yep.
Okay. And who is Attorney Yar? Who's the committee attorney?
Attorney Jones, Gregory Jones.
Oh, Greg Jones. Okay. I'm more inclined, Attorney Pockington, and I appreciate your constructive participation as always, but realistically, August 1st really only gives Mr. Kalbach 60 days to figure out what's going on. I don't know. When did EMAC say they'd get back to you?
So basically, I am about to deliver the package. It's about a 30-page package with supporting documents and whatnot. I was going to hand deliver it either today or tomorrow. They gave me an expedited time frame of approximately 2 weeks, but that was a brief conversation that I had with them. So,
and just for perspective on their timeline, Your Honor, I think 8265 has because it is a statutory program, as Your Honor knows. I think they have a 30-day expected statutory turnaround. If they're going to expedite it for him, that's great. But I was running my number or my calendar sort of off the assumption that they take as much time as they were allowed to take.
Yep.
But if we want to go a little bit further, maybe towards end of August, I'm not going to jump up and down about it.
No, and you know, realistically, if EMAP doesn't pan out and Mr. Kalbach comes back and say, "Here's my listing agreement. I've got here's the house is on the market. It's on the market at a reasonable number." What I'm thinking about, Attorney Pockington, is not having Attorney Jones incur additional fees and expenses if there's a way out of this. And I guess I could say no expenses before 30 days before the sale date, and that would give him enough time to put the ad in the paper and all that. So why don't we, and is there anything you'd like to say, Mr.? You following this conversation? You seem like an intelligent
just would it be appropriate right now to ask Mr. Pocklington about openness to alternative resolutions, or is that not appropriate for this venue? And if I want to reach out, it should be elsewhere.
He'll let you know whether it's appropriate. I don't,
so my question was going to be around okay, what would, assuming the writing is on the wall with the EMAP program and I have to go a different route, what would be an acceptable solution in terms of me looking for sale of the house, in terms of dealing with the representation for Hudson Valley to resolve this outside, to resolve this.
Yeah, unfortunately, there are, without crossing the line in terms of legal advice, you have any number of potential options. But ultimately, what I tell homeowners is that the homeowner's intention is really the main motivating factor. If the intention is to move on with as limited disruption as possible, it's one thing that would be like a waiver of deficiency, but with your equity, there wouldn't be a deficiency. If the intent is to move on with as much cash as possible for later on in life, then private sale. If the intent is to retain, there are other options, but ultimately, at this point in the process with where you are, I'm sorry, Your Honor, I'm talking directly to the homeowner. I'm treating this more like a mediation session than anything else.
I'm sorry. I wasn't asking for advice. I was more asking for, in your role as representative for the lender, what would be acceptable to you, in terms of not being back in front of the judge. I
can probably answer that question for Attorney Pocklington. Because of this, we're all proceeding on the basis that there's a cushion of equity in this property. So in cases where there's a cushion of equity, the lender, all you need to know from the lender is what's the damage, what's the payoff number, and you give them the payoff number and they go away quietly. But they're not expected to, nor is it customary for the lender to play let's make a deal when the debt is on its face appears to be completely secure. So it's rare for a lender to compromise. What they're doing is giving you some time to try to sell the house so that everyone wins here. They get what they're owed, you get the most you can out of the deal. And
I'm sorry, Your Honor. I'm not expressing myself clear. Again, I'm not looking to let's make a deal. I'm trying to ascertain the tick-tock of alternative scenarios, not numbers. So
the TikTok is I'm gonna set a sale date for sometime in probably the middle or end of August. If between now and then you come back and say, look, I've got a listing and this thing is hot and I've got all these showings, then in all likelihood I would further extend that sale date to give you a chance to sell the house. At some point, if the house doesn't sell and you don't lower the price, the shoe starts to pinch somewhere in this process. But we've got a little bit of wiggle room before the shoe's going to pinch in a way that I'm going to have to make some uncomfortable decisions that impact your life even more uncomfortably, a lot more uncomfortably than me.
Okay.
If I may, just to help you think about it, Mr. Colbeck, the timeline is reactionary to the situation. So what you are doing, right now, this hearing is a perfect example of until either yesterday or the day before we had the appearance that you had your head sort of in the sand on the process and that the action was just proceeding without your involvement. Now that you've appeared, you've asked for more time, you've explained why more time is appropriate, the EMAP application potential listing, His Honor is going to respond by adjusting the timeline accordingly. If you change your circumstances, you make another motion like the one that you have, His Honor or another judge at the Litchfield Courthouse, myself or another attorney from my office representing Hudson, will have a conversation about what these timeline adjustments, if any, are appropriate based off the situation. So the timeline is reactive. The timeline is not the point.
Okay. That's more in line with what I was trying to ascertain. Thank you.
And then at the end of the day, the court ultimately has the last word on the timing on these things. And the court, in most cases, reacts also to what's the reality on the ground. What's realistic here? What's going on? Is your plan reasonable? Is the bank being reasonable? Is there enough equity that we have some wiggle room, or are we in dangerous waters where the bank's at risk of being underwater, and then that puts you further at risk for a deficiency judgment? There's just it's a stew of considerations, all of which are in the mix when these issues, and here we are, like this is Exhibit A, right? We're together, we're gathering information, we're assessing the situation, we're coming up with a reasonable next step. And if we get together again, we'd have the same type of conversation. And we're fortunate today because the bank is, for lack of a better expression, they're chill at the moment to give you some time.
Yes, sir.
His Honor has seen me jump up and down more than a few times when appropriate under the circumstances. These are not those circumstances, sir. So you're saying mid to late August, Your Honor?
Yeah, I'm looking at August 22nd.
Works for me.
And I think Attorney Pockington, we're going to have to ask Attorney Jones to go out at least from 11 to 12 on Saturday, so that if people show up for the sale, they can be advised that it's been postponed until August 22nd.
That's consistent with the standing orders, Your Honor. And I'll give him a phone call when we're done to let him know. I'm sure you'll have the clerk do that too, but
yeah,
better he hears about it twice.
I'm not even sure. I may be deviating from the standard order because they may say 2 hours, but I think 1 hour before the sale is sufficient. So don't panic, Mr. Kalbach, if Attorney Jones is parked in his car in front of your house from 11 to 12 on Saturday, just so he can fend off any. And I don't know what he'll do with. Is there a sign in front of your house too?
Yes, sir, there is.
I don't know what he'll do with that, because it save you some money if you can use it again in August and not have to just change the date rather than the whole mess.
Well, let me just comment on that. When I mentioned that I was educated as to what the actual circumstance was, I reached out to Attorney Jones to understand what the process of the auction day was going to be like.
Yes.
And basically he explained that my understanding of the scenario was completely wrong, which is what sparked off my response and led here. So meaning he seems like a good guy. I'm sure we'll get along. Is my point.
He's nothing but a gentleman. Just doing his job. And all right. So I think anything else we should cover?
August 22nd.
All right. And no committee fees to be incurred prior to 30 days before that sale date.
Thank you. Thank you, Your Honor.
I'm sorry. Just quickly, where am I going to find documentation to this, or are my notes just going to be what it's going to be?
No, you'll get a piece of paper either emailed to you or sent in the mail that my order will be reduced to writing, and you will get a written copy of my order.
Okay, great. Thank you, sir.
All right.
Just to explain that, sir, because now you filed an appearance form with the court as of the 20th, you'll start getting a lot more in the mail.
Okay, great. Thank you, sir.
Yeah, nothing's going to happen without you being advised.
Thank you, Your Honor. Thank you, sir.
I thank you. Thank you both, and hope to see you soon. And again, my strong advice, Mr. Kalbach, is that if EMAP doesn't work out, that you talk to a realtor and start putting the ducks in a row to maximize what you can capture in terms of the value of this property.
Yes, sir.
All right. Thank you.
Thank you, everyone.
We'll
Goodbye.
see
Thanks,
you.
Edwin.
Is there anything else you'd like to say, Ms. Gupta?
Just please don't punish my daughter because of me. And please just do what is judicially right. The probate judgments are final orders. According to the U.S. Supreme Court, they are final judgment orders that were bestowed upon her, and she needs to pay them. She needs to pay the trust back. She needs to pay me back. You know what? I don't even care. She needs to pay the trust back, and she needs to pay my daughter back, and she needs to pay him back with interest, and she needs to be sanctioned. It's what is right, it is what it's just, and it's what she deserved. She deserves, and she needs to have her wages garnished, because if she doesn't, she will never pay. And that's, please refer to, if you're not going to grant it, at least please refer to all the case summary and all the work I put into that summary for motion judgment. And please, she also needs to be held in contempt of court. She needs to be held in contempt. She should be in jail. I'm sorry. She should be in jail. What she's done, she should be in jail. And if it was anybody else, if it was me and I was doing what she did, I should be in jail. And if it was my daughter, and if my daughter was doing what she did, she's been doing for the past since 2023, my daughter should be in jail. It's disgusting. I just don't understand. I didn't come here as a pro se party and just go hippity bippity bop. I did everything I was supposed to do. I did everything by the books. And that's all I'm asking, and I won't say it. And I just thank you for your time, Your Honor. And again, just please don't punish my daughter, and don't punish my daughter's trust because of me. Just stick to the law. And if you stick to the law and you stick to the Supreme Court law and the Supreme Court rulings, then it will go in the favor of the trust.
All right, is there anything that you'd like to say, Ms. Arden Gupta?
I mean, pretty much everything that my mom has said and that she submitted in the evidence. I mean, from my understanding, it's all 100% true. I've been there since the beginning, and my mom's been the only one advocating for me through all this. So, I mean, that's really it. Everything that she submitted is 100% true, and anything else being said is not.
And it's not like my daughter and I get along. And my daughter can attest to that. So don't think that her and I are buddies, because we fight probably more than anybody else. It's what's judicially right. I am the trustee of her trust. I am protecting the trust, which is my daughter's future. I'm doing what my father wanted, which was my daughter to have 50% of his estate, which this is all that's left, is 50% of his estate. And she didn't even get that 50% because of Ms. Previs's dishonesty from the beginning, taking out fees that shouldn't have been taken out more attorney's fees. Do you know how much Stephen Levy got out of this estate for doing I don't know what? And he was the second attorney. You know who the first attorney was? The attorney that Judge Diane Blick, the attorney that she appointed as my father's attorney for the conservatorship case that I filed, that my dad was all for. He wanted it because he wanted Miss Previs out of his life. And he didn't know how to get away from her. And he was for the conservatorship case. But I was here in Florida, and I had gotten him, Miss Previs had him trapped in Litchfield Hills nursing home because it was COVID. She never went to pick him up. His release date was September, believe it or not, it was September 11th of 2021. She wouldn't return their phone calls. She wouldn't return anyone's phone calls. And they didn't know I existed because she said he didn't have a daughter. And the administrator there, God bless her, she lost her job because of this. She told them he does have a daughter. I went to school with her. She lives in Florida. And they finally got a hold of me. That poor woman lost her job because she breached confidentiality, because I was no longer his executor or his whatever. Hildy was, because Hildy went and had his will redone with the most corrupt lawyer in all of Litchfield County, Patrick Wall. My father was so cognitively impaired by that time. He had 2 or 3 strokes. He was completely right side paralyzed. He drooled out of his mouth. He couldn't even speak or understand. He weighed about 5 pounds. When I rescued my father from the nursing home 8 years after I left the state of Connecticut for Florida because of my health, he was wearing the same damn clothes as the day he helped pack Lippincott moving truck on July 4th of 2014.
Oh my.
That Arden, is it the truth? That woman never even bought him clothes with $1 million in the bank that she was the power of attorney over. I had to re-wardrobe him. I had to buy him everything. All his house, she put siding on his house and new windows on his house with his credit card, racked up a $10,000 bill that was in collections like 10 times over. She did this when he was in the nursing home. He wasn't even there. Why did she do it, Your Honor? Because she thought she was going to get the house. Because she thought Kelly Kupta was never going to come back into the picture again. Kelly Kupta doesn't exist. Kelly Kupta is off down in Florida and doesn't know anything that's going on right now. She had new siding and new windows and new awnings put on my father's house while he was rotting away in Litchfield Hills nursing home with his one credit card that he never ever used, because the man used cash, nothing else but cash. And the timing, when I got all the bills and I had everything sent to me and I looked at the timing, October 2nd of 2021, she did this. My father was in a nursing home. She did it with his credit card because she thought she was going to get the house. And then guess what? Kelly showed back up. And what I started saying is the judge who appointed this attorney from Waterbury to represent my dad's interest in the conservatorship, the judge dismissed the conservatorship, said, no, Hildy gets to keep him. And then Hildy went and hired the attorney. And that was her original attorney. And I filed a motion that it was, I lose track of words sometimes, so hold on. Conflict of interest. I said it was a conflict of interest, Your Honor. And Diane Blick said, I don't see any conflict of interest. And this was her attorney at the beginning. And then all of a sudden, one day he disappeared. And now she's got Steve Levy and Bill Conti as her attorneys. $400 and some odd an hour coming out of my daughter's estate. It's almost 60 grand. Those two were paid. And then she's still taking the estate is closed, and she's still taking attorney's fees, proportionate attorney's fees out of my daughter's estate, and refuses to show the court the documents that she was supposed to file 30 days after she was made trustee. She was supposed to file these PC 440 inventory, distribution, and something else. She never did. And that's when Judge Richards figured it out. And that's when he started this case. We didn't start the case, Your Honor. Judge Richards did. And said, Hildy Previs, you never filed these documents. He started it. Whatever it's called, I don't know what it's called, but he started it. She and I were never the wiser. We didn't know she didn't file these documents. He is the one that started it. And then it just kept going and going because she wouldn't file them. And look it, did she file them now? Did she file them as part of her evidence that she just filed 2 days ago, waited to the last minute again? She still's not filing them. Why is she not filing them? Because she didn't take any of that money out of my nephew's. He only got a 25% share, and he got his share in cash. And not only that, she gave him $10,000 out of the estate before the estate was even closed. My daughter didn't give permission for that. The guardian ad litem that was representing her daughter didn't give permission for that. She took $10,000 out of the estate before the estate was even closed and handed it over to my nephew, who's a freaking pothead. Why did he need $10,000? When if he could have waited a couple more months, he was getting $75,000, but he needed $10,000. He lived with my brother for free, 34 years old, lived with my brother in a beautiful house in Goshen for free. Didn't work, didn't go to school, doesn't have an education, but somehow he needed $10,000. Hildy took it out of the estate and gave it to him. Not the trust, took it out of the estate. And then her daughter, another 25% share. Did she take this $919.56 out of her daughter's trust? Did she take it out of her son's trust? We don't know because she never filed any of those papers. That is why it's owed back to my daughter's trust, because we don't know. And that's what Judge Richards intended. You have to pay it back because we don't know. It's unsubstantiated. You have to pay it back.
Okay. I wanted to give Ms. Previs an opportunity to put on her case. Is there anything you'd like to tell the court? I'm ready for you if you're ready.
That has to be about the trust, this case. Nothing else, Hildy, because I will object.
All right, and Ms. Cook, I just would acknowledge that Ms. Previs did not interrupt you when you were putting on your case.
All I'm going to say, Your Honor, is she's going to start talking about stuff when I was a teenager. She's going to start talking about stuff with the estate, my father.
You just did.
So if you have an objection, you can register your objection and the court will rule on the objection.
I don't even care anymore. I'm so sick. I just literally want to throw up right now. So have at it.
Okay, Your Honor. So the reason that I submitted the paperwork just recently, actually there was more documents.
You cannot talk about evidence that's not in record. Objection.
She's not talking. She's telling the reason that she submitted things. She's not telling me what those things are.
She's about to start talking about evidence that's not in record and it's not submitted.
All right. About to doesn't. I'm going to wait until hear what she has to say.
In the beginning of this case, I thought that as it went on, that I wanted to obtain counsel once you decided that it was going to go to trial. I had spoken to different attorneys and I realized that the cost was going to be outrageous for me to even do that. So I assumed that, now I need to handle this on my own. Because there are certain things that I wanted to enter into evidence that I wasn't sure of ways to be able to obtain them. Because it is through the probate court. And I thought it would be quite easier for an attorney to get them for me. But in talking to the law library, they enlightened me on a lot of things. So I realize now there is ways for me to try to do this on my own. So there are other things that I actually would like to submit into evidence. One is actually a main factor that I'd like to. So I'm asking also that I could have time to obtain that and submit that into evidence.
Nope.
It's really important to my defense
Nope.
because I do have the right to defend myself.
You had time to defend yourself.
So Ms. Previs, I believe this matter was set down for trial. Let me just look at the notices that were sent.
Your Honor, I'm going to let you know that my health cannot take this and I'm going to end up dead. And if you want that, I'm going to put that, I want that on record, that my health cannot take this. She had plenty of time. This is what she does. This is her game. This
If
is
we'd
her
like to
shtick.
talk about, if we'd like to talk about health, we can bring up health because actually I do have a disease and it's terminal. Okay. And I am going to die. And I've never brought this up before. So if
It
you'd like to,
doesn't matter, Hildy. It
I'll let
doesn't
you know.
matter. Whether
Okay,
you're
so
terminal or not, there are
okay.
still court dates
I
you
don't-
have to abide by. You
So don't
just
talk about
think that
health.
you could do everything on your own.
Can you stop talking about your health then? Because I don't want to hear
I'm
it.
not going to stop talking about my health because my health is important to me.
Oh, so is mine. So let's be quiet.
Then just pay
About
what you
health.
owe and be done with
This
it.
is the reason why this has happened. This is the reason. No one wants to deal with you. No one. Why do you think the bank gave you a hard time? That video that your father made.
You
said it all.
cannot.
Said
You
it all.
forced a crippled, cognitively
I did
declined
not.
man. That
That
the
is
most
untrue.
disgusting thing
You
that
have-
I've ever seen.
You have said to the court that I killed my father.
You
I
have
killed my
killed
mother.
him.
What do you? My mother died. My mother got sick when I was 4 years old. I watched her suffer and die. My
You
father got
killed
cancer
my
and I sat
father.
there and-
I don't
So
care
don't-
about your parents.
I took care of your father.
I do not care about your parents. You killed
Right.
my father. You did not give him a simple pneumonia
No, I did
shot.
everything possible for your
killed
father.
My
I did
father.
everything for your father. I took care of him.
You
While you were sitting in
absolutely
court.
did not, Hildy, because he would still be alive. He was 70-something years old. He
You don't
packed
realize
up my
sick he
moving
was.
truck
You
8
would have
years
came
prior.
with him. Maybe you would have saw what was wrong with him.
It has
You'd have
nothing to do with the money that you owe. You judicially owe money. You need to pay it.
When I entered in, when I took the seat, we're talking about 3% here, or 2%. We're talking about 2%. We are talking about 2%. When I handed over that trust to you, Arden, the amount that Arden got was actually more.
Hildy, you were court ordered to start a trust with $149,258.18. You stole $4,000 out of it.
If Arden was to get $149,000 in some money, at the end of it, once I turn that over to you, minus my fee,
You don't get a fee. It was denied.
Can you stop, please?
No, I'm not going to stop because you're talking ridiculous.
You took it to court. You took it to court, right? I asked to be removed. The reason I asked to be removed
You
was
did not ask to be removed. We
can I
took you
speak?
to court to be removed.
This is
The
why.
judge has the court documents in front of him.
Ms. Cook, I'm going to ask that you not, once she's done, you can say whatever you want, but
Myself, then. You have
Pardon me?
why are you allowing her to lie then? You have the court documents in front of her. She did not ask to be removed.
she's testifying under oath, and I'm going to allow her to proceed to testify.
So you're okay. Oh, good. Then you're allowing her to lie. All right. Then how do I mute myself? Somebody help me.
You just
I didn't
mute yourself.
realize you
No,
were
you
allowing her
mute
to lie.
yourself
So
by
allow her to lie.
you mute yourself by not saying anything and letting Ms. Previs have an opportunity to testify.
That was good. I will. I'm quiet.
Okay, so in that time, so now I even forgot where I was. So when I handed out, well, some of the evidence that I put in there, there's one key thing that I would like to submit, which I don't have. The probate court actually has possession of it. And I didn't know if I would be able to obtain it, but apparently I should be able to. when I actually decided to remove myself is when I started going back to court once again, because when the final inventory, we kept going back for the final inventory because of exactly the behavior that is displayed by Mrs. Cookta today. Nothing is ever good enough. Everything I submitted, when I submitted initially, I submitted the bank statements. Arden's money was in the CD. Arden's money was in there. That's exactly where it was. I took, at the end of it, when the reason I didn't deposit the whole initial amount at first is because at the end of an estate, there's always extra expenses. The final bills from the courthouse, the final bill for the attorneys. So you have to leave money aside for that before. So maybe I should have waited and paid those bills first and then open the CD accounts. Maybe that's what I should have done it. Then we wouldn't have this argument here. Maybe that would have been a better thing to do. But in all, I did not agree with Mr. Richards not allowing me to take a trustee fee at all. I did not agree with that. The reason I asked to be removed because I was tired of going back and forth to court. I had explained multiple times, and each time that we went to court, the money is there. They saw that the money is there. We are talking about 2%. 2%. And in the end, once I handed it over, she still was more than what she was initially going to get to begin with. And of course, her attorneys are going to want to keep arguing back and forth because what do? They make money. So they keep going back. So I asked to be removed. And when I asked to be removed, I told him that if he was going to place Mrs. Cookta, I did not want to do it because that is not what her father, Mr. Cookta, wanted. And if you've seen the video, which he obviously never saw, the video of the will, Mr. Cookta made a video of his will, explaining things in that. I thought that was very important. He would not have
Objection.
What's the basis of your objection?
Because the video, first of all, is disgusting. The video,
I'm not seeing the video. I'm not going to look at the video.
Exactly. I have the video, not Hildy Previs. I have it. She has a copy that was altered, and Judge Blick still allowed it to be played. Again, let it be known for the record that Judge Blick had to recuse herself from the case. That's it.
Also, during the time, during the estate, and I had asked Mr. Richards several times, Kelly Cookta was, there was a court order.
We are not talking about the estate, Hildy. We are talking about the trust, the money that you owe in the trust.
And you know what? The $39,000 that you owe to the estate would have went into
I owe nothing to the estate. That $39,000.
My daughter,
Hildy,
her brother, and Arden.
Objection.
And
Hildy,
you were court ordered to pay it back.
The court order was lifted, Hildy, because your attorney.
No, it was not. I have a copy of the court order, and I submitted it.
Your attorney, are you going to listen? I wrote a letter. Your attorney has the letter. The judge that was there for a day has the letter. Your attorney did not want. I said, very well. That $39,000 was to pay the bill for Litchfield Hills Woods. I am speaking.
You had
and your lawyer and the lawyer for Litchfield Hills Woods went and finagled a $75,000
What are you talking about?
When the bill, I submitted all the bills. The bill for Litchfield Hills Woods was $39,500. That is why $39,000 was taken out.
See them.
Hildy, I was owed
You
I
stole.
was owed over $90,000
Oh,
from the estate
oh
that
my
I
God.
could have very well billed the estate for every single penny that I was owed. How do
Then
you
why-
think the estate had no
You're asking.
creditors? How do you think the estate had no creditors?
That
When
is
you
not-
owe the estate owed $10,000 to a credit card company. The estate owed $36,000 to
Your
Medicare,
Honor,
to Charlotte
this
Hungerford
is right.
Hospital.
What
How
happened?
do you think? Who do you think paid the nursing home bill for the nursing home that you and your swindling daughter worked at?
This is
Who do you think paid that bill? Did that
Mr.
bill from?
Prohibited.
Did that bill? No. Who did that
I
bill?
worked there. Mr.
Did your
I
did your
wrote the
nursing
check
home?
right to them. Yes.
You're
not-
making, we're recording everything that's being said, and we're making the job of the person who's recording impossible when you talk over each other.
Hildy Previs doesn't understand that I could have sued the estate for $96,000. That would have come out of Bryant, her stepson's estate share, the 25% state share. That would have come out of her daughter's 25% state share, and would have come out of my daughter's 50% estate share, because that was money that I paid for my father's bills, to cover all his creditors, to pay all his back taxes on his house, and for everything else that she was supposed to pay as his power of attorney, and she did not pay. All that money came out of my pocket, out of my savings, out of my FRS fund here in Florida, my retirement fund. I paid all that, and I could have sued the estate, and that is why her attorney, Stephen Levy, dropped everything, because he didn't want any of that, me suing the estate for the money that I was owed. And she has the audacity to come here and try to bring up that again. Hildy, you are very misled. Very misled.
You like to lie.
I'm under oath. I'm under
Yeah.
oath. I don't lie.
You're both under oath.
I'm under oath.
Yeah, and you're lying.
All right, so I think we need, the person that's recording and the clerk are entitled to a 10-minute break at this time. So we're gonna stand in recess until 3:35, and then we'll come back and allow Ms. Previs to finish whatever it is she wanted to say. So let's stand in a brief recess.
Text me.
All right, and it looks like we're back on the record and.
Not yet, Your Honor. Your Honor.
Oh,
Okay. Now we are. Thank you. All set.
Okay. And we interrupted Ms. Previs in her testimony. Is there anything else you'd like to say to the court, ma'am?
Yeah, as far as the court orders, and I don't feel like I didn't feel like it was justified. I didn't feel that it was right. Miss Gupta had taken the $39,000 from the estate and still had to owe it back. I feel like she stole from the two others, my daughter and my daughter's brother, from the estate. Also, that money was taken after he died, and it was done through a bank, through the internet is the way that she did it. She seems to do things quite calculated so that no one knows what she's doing. She said, I have been dealing with this for a number of years. I took care, when I decided to take on this role, initially I didn't even know that Mr. Gupta was putting me in place, and he did. And I took care of that man. I did everything for him. I hired people to help him. I sat with him in nursing homes when he was sick. I picked him up off the floor when he would fall at home. I washed him when he would defecate himself. I did everything for him. I was good to him. And I really feel like what she's doing to me now is because of their own guilt, her own guilt, that she wasn't there for him. He wasn't my father, but he was very good to my father. And that's another reason I had a lot of respect for Mr. Gupta. He was a very tough man, but he was always very kind to me. And I used to say to myself, I don't know if he did this because he really likes me or if he did it because he hated me, because this is what I have to deal with as his daughter now. And that is one of the reasons why I asked to be removed as the trustee, because initially when I started the trust, I did it out of good faith. You know, I figured I'd put the money in the account for Arden as a CD. It would gain the best amount of interest for her in the end. I even remember I sent her a message to let her know. I said if there was anything that she needed, she could let me know. I tried to be kind about it. I didn't want to do anything that was gonna hurt Arden, or, you know, I tried to do the right thing. And I do believe that if Mr. Gupta knew this was going on right now, he would be so upset. I don't know why he would want me to go through this for so many years, having to argue back and forth. I don't want to relive this all the time. You know, it was enough to watch the man suffer and then pass away. That was hard enough for me. I did it with my two parents. I've sat through these court hearings in the past with Mrs. Gupta, and she has talked horribly about me. Called me, you heard her, called me a piece of shit, white trash, and I have sat there and I have listened to it, and courts have allowed her to talk to me like that. And it's frustrating. I don't feel I should be treated like that. I'm the woman who took care of your father. You should be grateful. And your grandfather. I did it because I cared about him. There was no one else there to help him. His son wasn't there. His daughter wasn't there. There was no one. He had no one. And I set aside a lot of my life to be able to take care of him. And my daughter she was younger at the time. She was 16. She was going through those troubling ages. And I wasn't there for her part of the time. A lot of times I had to be at the hospital, do different things for Mr. Gupta. But I felt like when we started arguing about, it was 2% that was missing from that trust, which I took as a trustee fee, 2%. And it dragged on to court costs or whatever she says, $18,000, whatever there was no reason to take it to go to court. There was no reason to keep going back and forth. The bank statement was there. It was there. It showed what was in there. It showed in the end when I turned it over. Actually, by the time Kelly, I'm sure she obtained by the time she got the money, it's more than the 150 plus thousand that I believe I submitted that to the court. That was the last paperwork that I had submitted with the final accounting. But every time I put a final accounting in, it was never enough. We'd keep going. We'd have to go back because, oh, they wanted more. They wanted this. They wanted that. That was all I had. I had the statements. I had the bills. For the $919 that totaled out that, I gave the receipts for that. One of the receipts was Attorney Levy. There was court fees. I forget what was on that paper. I handed in those receipts. The courts had those receipts. They were taken. That was Arden's share of it. It went 3 ways. And you could tell it went 3 ways if you looked at the receipts and you divided them 3 ways. That's how it came up to the $919 that she's claiming that. I don't even know. I don't even think that was ordered for me to pay $919. But, and then once the court ordered me, when Judge Richard had ordered me to, pay these fees, I was very upset. I said, you know what? I'm not going to pay that back because I didn't think that it was fair. This woman also had a court order to pay back money. She never even paid back. She stole from my daughter and my daughter's brother. Not to mention, that was after he died. And then after he died, she even went as far as having Merle Automotive break into the house, into the garage and take Mr. Cookta's truck. And somehow it's gotten the title from the house. And all of a sudden, after Mr. Cookta died, she said, oh, he gave this truck to Arden. Well, if he gave it to Arden, then why? And I tried to go to motor vehicle to get a copy of that. I called the police, the state police, because the neighbors alerted me that that Merle was there, and it was Kelly. She's calculated. So not only did Kelly benefit from the $39,000, there was Mr. Cookta had a truck, a brand new truck with a plow on it that she had removed from the house because all of a sudden he gave it to Arden. But nobody knew about it. Mr. Cookta noticed that his title was missing. He was furious about that after he got back from the nursing home. We didn't know anything about it. So right after he died, next thing you know, Merle Automotive was breaking into the house. He broke into the house because Kelly had no access to the house because she wasn't allowed there. The woman at the bank gave her a hard time about obtaining the funds to Arden's trust. I'm sure I saw that in one of the memorandums. She said probably because she was mortified and wondered what happened too. Mr. Cookta did not want this, and I did everything that he wanted, and he would be furious with this right now. I don't have the money to pay her court fees and everything else. Why did she even bother to hire an attorney? Why would you hire an attorney? She's sitting here in court right now doing all this herself. Why did you hire an attorney there that's going to rack up all these bills? The attorney didn't care. He would keep going back because he's making money. I don't think Judge Richard really took a look at the case. I think he was upset with it too. And during the case of the estate involved Arden. Arden was 18 years old at the time. Arden was able to speak for herself. She never spoke for herself. Her mother kept butting in and was speaking for her. And Judge Blick, she didn't like Judge Blick because Judge Blick said, you cannot speak. This does not involve you. Every judge, and then we had Judge Yeaman. Judge Yeaman was there once, and then she retired. And then we got Jordan Richards. And that he let her speak all the time. All the time he let her run her mouth. Arden barely ever spoke. Ever. In fact, the same day that I decided to remove myself as trustee, I asked to be removed as trustee, Arden was not even on the call. It was supposed to be Arden on the call. It was Kelly on the call.
Watch yourself, Hildy.
Watch
yourself.
I'm not finished.
Remember, you're under oath.
I am under oath. Yes, I am. And so are you.
Nothing that you are saying is in record. You realize that. I'm just reminding you. Literally nothing that you are saying is in record.
This is okay, and this is why we are here today. We're
here today because you didn't pay your judgments. You have judgments against you that you did not pay. That is why we are here today. You
And I
never
feel the
even tried to
judgments were
make
wrong.
good. You
Okay.
never you never
Oh my-
called, you never said, I could pay you $5 a week, I could pay you $20 a month. You never did anything. You're Hildy Previs, and these things just don't apply to you. Just like it doesn't apply to you that Judge Rohrbach
Was I speaking or
filed
was
this
it?
trial. He set this thing
All
for
right.
trial for almost 40 days ago, and you just decide to throw some stuff at the court 2 days ago, and you put it in snail mail to my daughter and I, because nothing applies to you. Nothing applies to you. And now
And
you're asking this
you
court,
listen.
you're asking this court to give you more
my-
time, waste more time. No. It's time to pay the piper. You owe this money to the trust. It wasn't a suggestion. Judge Richard was not suggesting that you pay this money back. He was court ordering you. It's a final judgment. You have to pay it. You owe $3,000 plus interest to the trust. You owe $919.56 plus interest to the trust. You owe $2,500 plus
Oh my
interest
God, please.
to this young lady right here. You hate me? Come to Florida. I'll take you out to lunch. You could write a book on how much you hate me. You know what? I'll even stand still and you could beat the crap out of me. I'll get down on my knees since I'm 5'11" and you're 4'0". We could do that. We can have those conversations, Hildy. I don't care. I really don't. This isn't personal. You owe this money. Those weren't suggestions. Those were court orders. It doesn't matter if you don't agree with Judge Richards. It really doesn't. At the end of the day, it doesn't. You were court ordered to pay these things, and you have to pay them. That is why we're here in Superior Court now. And if it doesn't work out in Superior Court because someone else has it out for me, then we're going to go to Supreme Court. I'm not done with this. Until the day I take my last breath, which might be sooner than later because of you, I'm going to fight this. Not for me, because not a penny of it is for me. It is her money that Richard cooked up. My father, not your father. My father, who you wrote yourself out a check for $1,000 every week, whether you showed up or not.
Are you kidding me?
I have all the bank records, Hildy.
That's it. Oh, really?
Another young lady who said that you would write checks out to her whether she showed up for work or not.
This
You
is
stole
ridiculous.
from my father, and you over and over and over and over again. And my poor father, you're right. He had no one else that cared about him because he was a hard man. You're right about that. He was a hard man. He was a difficult man. I know, because I am his daughter who grew up underneath his household. You're
Who
not.
left you nothing?
You are a
Who left you
woman
nothing
who
for a
married
reason?
my brother
I could steal from your
20-something
father.
years ago.
Oh my
That is
God.
all you are. You
Oh
did
my
not
God.
come to my father. My brother dragged you in so you two can concoct
Oh
something,
my God.
because my brother was
can't.
estranged from my father. So you two can concoct something to
Mhm.
deplete him of his entire savings, which is exactly what you did. So for you to sit there and say, I took care of him, who was with him in the hospital over the phone when he took his last breath, because you
Not
could
you.
not bother giving him his annual pneumonia shot? Who was from 1,400 miles away with him when he took his last breath? It wasn't you, and it wasn't your daughter. It was me.
That is
And
so.
you had to get permission to go see him and his dead body. Why? Because power of attorney dies with the decedent, and you no longer had control of him anymore. And this is why you've made me pay and pay
Oh,
and pay.
God.
And it's so easy to point fingers at me because I'm more educated than you. I have more degrees than you. I have a bigger mouth than you. And I will fight you tooth and nail. And because my kids are wonderful. My son works at PricewaterhouseCoopers, makes $2.5 million a year, and lives in Washington, D.C. My daughter is sitting right there, 23 years old, works for the same pharmaceutical company that she's worked for the past 6 years. She graduated high school with an associate's in business. And what does your daughter do? She's your partner in crime. Tattooed it up, pierced up. The first time I saw her in court at my father's, one of those probate hearings, I didn't even know who the heck she was. piercings everywhere, tattoos everywhere.
Oh,
purple
really?
hair.
She's right here.
I
She's
don't
right here,
care.
so you can see her. with
I
her
don't. You
piercings
think
and
I
tattoos.
care? My cares are gone.
This is ridiculous.
Gone.
I can't do this, Your Honor. This is ridiculous.
You have destroyed my family. You have destroyed my daughter. You murdered my father. And this is not going to happen anymore. It's done. It's over. Pay the judgments. And if you want to have a conversation with me afterwards, you want to hash this out, however you want to do it, you and I could do that. As two sick women, you and I could do it. I'm more than happy to do it. But you have court orders, judgments, final probate judgments against you, Hildy. And you have to pay them.
Oh my
To
God.
the trust and to her.
Oh.
And you can make payments to me on the $750. I don't care.
Okay.
But this is where we're at. I'm quiet.
I think I've heard enough information, unless there's anything else anyone would like to offer today.
Arden,
Yeah,
you're a plaintiff. Speak.
Your Honor, the only
Told you
thing
that you weren't there for your grandfather.
Okay. The only thing that I'll say on my end is that regarding the truck, my grandfather gifted that truck to me before he passed. So whatever Ms. Previs was saying regarding that we took the will after he passed, or he had no idea that we took the will, that's completely untrue. I had just gotten my license, and I was in contact with him when he was back in his home. We had spoken many times, finally getting back into contact with him, and he'd known that, and he gifted me the title to his truck, and his
Did you
neighbor
honestly
across the
say
street
that, Hildy?
informed my mother that the truck was gone. It was out of the driveway, and so my mother called the police, and it was discovered that my uncle had taken the truck, and he had to bring it back, and then that's when everything was sold, and I was able to get my very first.
Arden, no, that's not what happened. I'm sorry, Your Honor. I didn't know that Miss Previs said anything about the vehicle. I have to admit that my computer died, and I was actively trying to plug it back in to gain some juice, and I was trying to call you on my phone, but then my phone died as well. So I didn't hear her say anything about the truck. So I will set you straight on the truck. My father gifted the truck to my daughter for her birthday. He sent the will, and he sent the keys. He sent, I had to do he signed the title over. I had to do everything over the phone in Connecticut. When my brother got wind of it from a neighbor that my moving guy was there with the flatbed to pick up the truck, along with two state troopers, a male and a sergeant female, two Litchfield County state troopers. My brother showed up there like a bat out of hell. I do not recall or not if Miss Previs was there, but my brother, Richard Cookta, my estranged brother, he's estranged from me, and he was estranged from my father. He was in cahoots with Hildy, his ex, and he showed up there, and he went gangbusters in front of two state troopers, and the female sergeant state trooper set him straight and showed him the title registration and all the proper title documents and everything else. Hildy is the one who called me, I believe, a day after the title and everything was mailed to me, because she went up to the house, and she went in the house to search. My father was very strange, and he kept all his documents and everything in some metal chest, but he kept them in his kitchen oven. I don't know why. That's just something that he's always done. Miss Previs knew where he kept those documents,
and she either had a key or she knew where the key was. And when she caught wind that my daughter got the truck because she wanted either her daughter or my brother's son to get the truck. And when she caught wind of all this, she stormed up there in front of the home health workers that I was paying. I think I was paying $27 an hour out of my pocket, and they were there 24/7. She scared the malarkey out of them because they had no idea who she was. My father was living in a hospital bed in the living room at that point, scared the hell out of him. And she was up there. Miss Previs was up there going through his box, looking for the title to the truck and the keys to the truck, which were already in my possession. And she calls me on my phone here in Florida, screaming bloody blue murder. Where is the titles and the keys to the truck?
Okay, we're getting a little far afield. I don't think the truck is implicated
I
in
am
the
just
dispute.
saying, this is how low down they were, that my father chose on his own to gift my daughter this truck, and they just wanted the truck. They didn't care about my father. They just wanted the truck. So no, the police were already there. I made sure the state troopers went with the auto body guy to get the truck. Actually, the state trooper, the female, had to crawl in through the back window of the garage because I had changed all the locks on the house at my own expense. And my brother and Miss Previs went and re-changed all the locks on the house. And then went and charged the estate, my daughter, the estate, for changing all the locks on the house, which is in all the documents that the court already has because they're part of the probate estate case.
Okay. Well, I want to thank everyone for participating today, and the court will issue a decision in a timely fashion. And I thank everyone for providing me with the information that you did provide me.
Thank you, Judge Rohrbach. All I can say is I'm sorry. And again, please don't punish the trust for me. You just don't know what this woman has done to me personally.
All right. Thank you. And with that, we will stand in recess.